Apologies for the delay in starting, but we had so many people and we need to get everybody seated. I'm really excited that we have such a full house for such an incredibly important topic. So welcome to the Hammer Museum. Tonight we're excited to present a group of scholars of constitutional and election law to review the recent Supreme Court decisions. And I want to express my gratitude to our co-presenters, the Safeguarding Democracy Project of the UCLA Law School. This summer, the United States Supreme Court, and actually in the fall, gave their rulings on cases that touch on many of the country's most polarizing legal and policy debates. Our all-star panel's here to analyze the meaning and implications of the latest Supreme Court opinions, including cases on January 6 obstruction charges, immunity for former presidents, and Trump's ballot eligibility, racial gerrymandering, abortion pills, the legality of the opioid settlement, gun rights, bump stocks, the NRA and the First Amendment, restrictions on the unhoused, interstate air pollution, the rights of social media platforms, and disinformation on social media, and less sexy but equally important, the power of federal agencies, administrative courts, and agency funding. Before we dive into tonight's discussion, I'd like to highlight a couple of upcoming programs we have planned at the Hammer. We have our Summer Night Cinema screening series starting on July 16th. We're showing mostly documentary films that were highlights at this year's Sundance Film Festival. So the first night will be a screening of the new Sundance documentary Daughters, which is about the relationships of incarcerated men and their daughters. And we're also showing the documentary Porcelain War about artists in the Ukraine who are fighting while also continuing to make fragile porcelain artworks. And there's lots of really great other films, so please check out our website for more information. And if you'd like to stay updated on our upcoming programs and events, please be sure to sign up for our newsletter, which you can do on our website or on the sign-up sheet, which is out in the theater lobby. So now I'm delighted to introduce our distinguished guests for tonight's conversation: Carrie Franklin, Justin Levitt, Eugene Wallach, Kimberly West Falcon, and Rick Hasson. Carrie Franklin is the director of the Center on Reproductive Health, Law, and Policy, as well as the McDonald Wright Chair of Law Faculty and the director of the Williams Institute at UCLA. Justin Levitt is a professor of law at Loyola Marymount University and was the White House's first senior policy advisor for democracy and voting rights from 2021 to 2022. Eugene Wallach is the Gary T. Schwartz Distinguished Professor of Law at UCLA and a senior fellow at Stanford University's Hoover Institution. Kimberly West Falcon is a professor of law and the James P. Bradley Chair in Constitutional Law at Loyola Marymount University. And our moderator this evening is Rick Hasson. He's a professor of law and political science here at UCLA and the director of the UCLA Law School's Safeguarding Democracy Project. He's a nationally recognized expert on election law and campaign finance regulation and co-author of the leading case books in election law and remedies. So after the discussion, we'll have a chance to continue the conversation over some light refreshments in the theater lobby. Quick reminder to please silence your cell phones. And now, thank you again for joining us tonight. And please join me in welcoming Carrie Franklin, Justin Levitt, Eugene Wallach, Kimberly West Falcon, and our moderator, Rick Hasson.
Good evening, everyone. It's great to see a packed house here. I'm Rick Hasson, moderator today, and I was thinking that the way the constitutional law professors on this stage experience the Supreme Court and its rulings is very different than the way the average person in the audience would. You see kind of a storm that comes in at the end of June, and we are seeing the rain coming all the time. And, you kind of think about what kind of perspective do you have on the Supreme Court if you just see it as an oracle that just gives you a ruling that comes at the end of June versus the kind of watching the evolution of law as it goes from year to year and even as it goes from decade to decade. And so what I hope we can do today is take the headlines that you've seen on the internet, in your newspaper, and put it into a broader perspective to understand more deeply what it is that the court's doing, what the court didn't do, and how it affects our lives. So the way we're going to start is I'm going to work my way down the line. I've asked each of our participants to talk about a case or a set of cases in different areas, in the area of reproductive rights, in the area of free speech and social media, Second Amendment and gun rights, and the democracy cases. So we're going to start there, have a little bit of back and forth about the broader themes of the term, talk about what's coming in the next term, and then open it up to you for about the last 15 minutes for some questions. So that's the plan. And I'm going to start by turning to Carrie. And I want to ask you, Carrie, about the abortion cases. A lot of people were thinking that we were going to get some very big rulings from the court coming a couple of years after the very important Dobbs decision, and yet we got something else. And I'm wondering if you could, why did this emerge in this way, and what meaning should we take from it?
So you all know that Dobbs happened 2 years ago. It overturned Roe v. Wade, and it means that I am going to be fully employed for the rest of my career because the Supreme Court is going to hear endless abortion cases. We've unsettled 50 years of precedent, and now we have a lot of questions. I'm going to talk about two questions that got to the court, and I'm going to say the way the media covered these cases was, I think, a bit misleading. So I'm going to end there. I will start by talking about Moyle. Moyle is a case out of Idaho. So in the mid-1980s, the federal government passed a law called EMTALA. And what was happening was that hospitals were, when people came to hospitals with emergencies, and couldn't pay, hospitals were just dumping them, either dumping them on the street or dumping them at other hospitals. And Congress wanted that to stop. So it passed a law saying if you were in an emergency situation, your life was threatened or your health was seriously threatened, hospitals have to stabilize you. They have to provide whatever care is necessary to stabilize you. So sometimes that care is an abortion. That might be what is necessary to save your life or save your health. Thus far, we've had Roe v. Wade, and hospitals were providing abortions in emergency situations when it was necessary. Now we have Dobbs, and Idaho and a number of other states passed very severe abortion bans. Idaho passed a ban that said doctors can only perform abortions when it would save a woman's life. There's also a rape and incest exception that's not relevant to this case. But only life-saving abortions may be performed in Idaho. If you have a serious health problem, like you have preterm premature rupture of your membranes, or you have other serious conditions where you might have some damage to your organs, you might lose your fertility, that kind of thing, that is not a reason a doctor in Idaho can perform an abortion. So we have a conflict between the federal law that says you have to provide stabilizing care if somebody's health is seriously at risk, and the Idaho law that says our doctors cannot perform stabilizing abortions to save someone's health. So this goes to court, and the district judge says that the federal law trumps. Federal law is supreme over state law. When there's a conflict, the federal law wins. This gets appealed to the Ninth Circuit. And while it gets appealed to the Ninth Circuit, the Idaho ban on health-saving abortions is stayed. The Supreme Court reaches down and says, we are lifting that stay because there might be irreparable harm to Idaho because it might be forced to perform a health-saving abortion that it doesn't want to do. That's a serious harm to it. We can't let that happen. Lift the stay, and we'll decide the case in the summer. So I'm sure many of you will have seen in the news, Idaho is now airlifting. People who come with serious health emergencies are being airlifted, medevaced out of Idaho, hopefully get to another state in time that their uterus can be saved or the health situation can be stabilized. That's what's been going on. We were waiting to hear this summer, and the Supreme Court came out with a decision that said, whoops, sorry. Well, actually, they didn't say sorry. They said, whoops, we shouldn't have taken that case. we're going to let it develop in the lower courts, and we're going to allow the stay to be in place while it develops in the lower courts. So that case is not resolved. We should do this again next year, and I'll tell you what happens, because I think it's going to get back to the Supreme Court, and we're going to find out what happens once it gets through the lower courts. I'll just a little on the tea leaves. We had 3 justices, Sotomayor, Kagan, Jackson, who said the federal law should trump. You have to provide emergency health-saving abortions. We had 3 justices, Alito, Thomas, and Gorsuch, who said, no, the federal government is not allowed to use its spending power in this way. It is not allowed to impose this regulation. The state is allowed to criminalize what it likes, and the federal government can't put this condition that wasn't clear on the law and require states to do this. And then we had 3 people, the chief and Kavanaugh and Barrett, who said, we just got to see how this develops. But maybe that spending argument that the state's making is pretty good. And maybe we're going to like some religious exceptions that say doctors don't ever have to perform this if they don't want to for religious reasons. And maybe we're going to say that mental health is never a reason to provide an abortion. So it looks like there will be some limitations on the right, but we'll have to find out what happens next year. Briefly, the other case, FDA versus Hippocratic Alliance for Medicine. This is a very consequential case that we will eventually get a ruling on. This involves medication abortion. About almost 2/3 of abortion in this country are now medication abortion. Almost 2/3 is a radical change in the last several years of using pills to get abortions. So this is a problem if you want to ban abortion now that people can just get pills in the mail. So in 2000, the FDA approved mifepristone, the pill, to use for abortion. In 2016, it lifted some of the regulations because this is an incredibly safe drug. It has about the complication rate of Tylenol. It's safer than penicillin, and it's safer than Viagra, and it's safer than drugs that are regulated a lot more heavily. So the FDA lifted some of the regulations in 2016 and said, you don't have to come in 3 times to a doctor to get it. A nurse practitioner could administer it. And then in 2021, they said it can be offered by telehealth. This is the FDA saying it's safe, so we're removing some of these regulations. Pro-life doctors incorporated in Amarillo, Texas. Think for a second why they did that. If you know the name Judge Kaczmarek, he was going to get the case. So they had an organization that they created called Alliance for Hippocratic Medicine, Do No Harm. They said they challenged the FDA's approval of this drug, saying what if someone has a complication? We might find ourselves in a situation where we would have to treat an abortion that goes against our Hippocratic oath. Judge Kaczmarek heard the case, and he issued a nationwide injunction barring sending mifepristone through the mail. Potentially, that is a somewhat tantamount to a national ban on abortion, right? No, you can't send it anywhere in the country. The Supreme Court, again, reaches down early and stays that injunction. The case goes to the court, and the court says those doctors don't have standing because their claim that they had standing to bring this suit, you have to have some skin in the game if you're going to bring a lawsuit. And their claim was, what if one day we ever had to face one of these patients who was having one of these rare complications? And the Supreme Court said, you've never faced it. You don't prescribe it. What you really don't like is abortion, and that doesn't give you standing to challenge the FDA's approval of this drug. That's, again, kicked down to the lower courts because I think there will ultimately be a plaintiff, potentially a state, who can have standing to challenge that law. And that is coming back to the court. That's probably the biggest issue on the horizon is, will the Supreme Court issue a ruling that severely limits the use of medication abortion in this country? And that will affect everyone in California and in every state. But you're going to have to stay tuned because the Supreme Court did not issue a decision in that case.
And just to be clear, we're not expecting any decision before the election.
Exactly.
Okay. All right, so we're going to turn now to the question of free speech. I'll say as a matter of disclosure that Eugene and I both filed a brief. Did you file a brief in that case?
No.
Oh, okay. I apologize, but you were relied upon by Justice Thomas in earlier incantations of this issue, and so we've talked about this before. Share with the audience what were the issues in the net choice case, and what were the kind of free speech questions that arise now in the era of social media that were not present even 10 years ago.
Got it. Okay, so let me see if I can actually set a timer for myself, because I could go on a long time on this. And the answer is,
I'll let you know.
My phone is, okay, there you go. Nope, not going to work. So you stop me when I'm going too long. Let's think about what we might think about as platforms for speech, places where we can all speak. On one end are things like newspapers. In principle, we could write a letter to the editor or write an op-ed. Now, the newspapers only take a small fraction of what's submitted, but it is a place where others can speak. And then, there are parades. Like we could enter a float in a parade using this privately organized parade. Or maybe have our books sold in a bookstore if we publish a book. At the other end are other platforms like the telephone system, right? You can talk to people using a telephone. You have to pay money to get telephone service. You can use a monopoly landline or quasi-monopoly, or you can use famously competitive cell phone companies. You can speak that way. There are platforms. Likewise, you can ship things through the mails, which is run by the government, or through UPS and FedEx, which are privately operated. So the question is, what happens when the government, either the federal or the state government, says, we think it's only fair that you, platform, have to allow all speakers, or let's say allow speakers without regard to viewpoint, or allow people an opportunity to reply to criticism. And it turns out that the court has had to face this in many situations. So when it comes to newspapers, the answer is, of course, the newspaper has a First Amendment right to say, no, we're not going to publish some submitted op-ed or some letter to the editor. We're not going to allow someone to reply to criticism that we published. Maybe we will, maybe we won't. But we have the First Amendment right to pick and choose what goes on our property. Parade organizers have the right to pick and choose which floats to allow. But at the other end of the spectrum, it's pretty broadly assumed that if the phone company says, no, we refuse to allow to have our phone lines to be used by communists, because, we're capitalists. We don't believe in communism. We don't like the KKK. We're going to, if the communists or the KKK want to use our phone lines for the recruiting or get out the vote or whatever else, we're just going to cancel their phone lines. They can't do that. They're a private entity, but they're subject to various non-discrimination rules. Likewise, California courts have said that large shopping malls have to allow people to go on the property and hand out leaflets, even if they'd rather say, no, nobody's allowed to speak that way on our property. And the Supreme Court said that's a permissible imposition on private property rights. Likewise, universities, the Supreme Court has said, I oversimplify, can be required to allow military recruiters, even if they would rather not allow military recruiters. So the question in the net choice cases was, where do platforms fall on the spectrum? Texas and Florida passed laws that, again, to oversimplify, said platforms can't discriminate based on viewpoint in the speech they carry. Platforms said, these laws are unconstitutional because we're just like newspapers. And the states said, no, they're constitutional because they're just like the phone company. And one federal court dealing with a Texas law said, yep, they're just like the phone company, just fine. These laws are just fine. Another court, the 11th Circuit, dealing with a Florida law, said, oh, no, that's unconstitutional because they're just like the newspaper. So what did the court decide? Well, it decided a couple of things. First of all, and perhaps most importantly, it said, yeah, actually, these analogies, they actually are important. Some people say that maybe social media are completely different. They're new, they're extra powerful, they're extra important. We should create whole new rules for them. In fact, 4 justices, 3 quite conservative justices, Thomas, Alito, and Gorsuch, suggested maybe that the court should take that view. And Justice Jackson on the other end of the court seemed to be open to that perspective as well, although perhaps she would come up with very different rules than the conservatives. But the 5 justices in the majority said, nope. Basically, let's say 3 conservatives and 2 liberals said, in an opinion written by Justice Kagan, who's a moderate liberal, said, no, we really do want to look at these analogies. The second important thing they said is, it's a mistake that the lower courts made to think that the platforms are all like one of these things. The platforms actually provide a lot of different services. Some of them, like this main feed the court kept talking about, main feed from Facebook, or the front page of YouTube. That's like a newspaper. In fact, you can think of it as like the front page of a newspaper. And there, the majority said, the First Amendment does protect the platform's right to say, we're just not going to allow certain kinds of views on our main feed. When it comes to like direct messaging, kind of the email equivalents that the platforms provide, like DMs and Twitter and the like, we don't know. But the majority seemed to suggest maybe it's quite different. And there are all sorts of other things in the middle, like when it comes to whether they just host a particular page, like real Donald Trump on Twitter or your own Facebook page. Those things, the lower courts, they didn't focus enough on them. They struck down, the 11th Circuit struck down the law altogether. The Fifth Circuit upheld the law altogether. That's a mistake. It needs to be looked at more of a feature-by-feature basis. So the one thing that the majority said is when it comes to this main feed, these curated feeds, where they prioritize, the platforms prioritize what is most important or valuable, those things, there's a First Amendment right. But as to the other things, it's left to the lower courts to decide. So it may be, again, many years before we figure out whether a platform has the right to just kick off your page altogether, or has the right to decide which direct messages it'll deliver and which ones it won't.
Thank you. And I should just add that there's also an issue in that case about whether platforms have to provide data and transparency.
That there are many other issues.
And for people who study social media platforms and whether or not, for example, they can cause damage to teenagers,
right.
They want access to that data. And that also was
not resolved. And if you want to add 2 other things that weren't resolved, but were flagged by some of the justices, 4 justices, Justice Barrett, who joined otherwise the majority, and Justices Thomas Alito and Gorsuch said, a lot of these decisions are being made through artificial intelligence algorithms. Should that make a difference? Do platforms really have First Amendment rights not to decisions that their employees, human beings, make, but that their algorithms make? They didn't resolve that question, but they flagged it. And one justice, Justice Barrett, said, well, some of these platforms might be owned and run by people in foreign countries. I wonder, she never mentioned which one, but I think we all have in mind which one. Should that make a difference? I'm not deciding it, but this is an issue that needs to be considered. So there's lots that's still left unresolved.
Thank you. Kimberly, we're going to turn now to the question of the Second Amendment and gun rights. This is a place where the court has very drastically changed the law over the last few decades. This term, the court had a chance to say something big about the question of how far these laws go and how to make these decisions following a lot of confusion in the lower courts. Can you tell us about the Rahimi case and what happened there?
Absolutely. I actually asked to have the gun cases, and I've also asked Justin, my colleague, and as far as sharing our law school, to give me a sense of when 5 minutes will be, because
I'm playing it a little loose.
Okay. Well, no, for me, I'm saying because, one, I want to make sure there's time to engage what I think is the right question, which is what do we have to offer as people who are, who study constitutional law. And so before I dig into the nitty-gritty about Cargill and Rahimi, because I'll talk about both of them, the bump stocks, and then a case about a very irresponsible gun owner who was subject to a domestic violence restraining order. But I do think it's important to, and I'm looking forward to this because Rick, you invited me back in 2018, and it has stuck with me, and I've mentioned it many times. One of the questions you asked is what keeps me up at night as a constitutional law scholar, and my 2018 answer definitely holds, so I'm sure we'll get to that. But I do want to say what is, I think, different about being someone who teaches and writes about constitutional law is that we read across, and I very much try to read across the topics. And so it's very artificial to talk about these cases separately if we're really going to interrogate what I would assume a lot of the people here tonight are most concerned about, which is the legitimacy of this court. Whether these are people whose opinions we should actually care about reading anymore. Do they have credibility amongst we the people? And I hate to say, as much as I can get in the weeds, and I teach a class that is on originalism, and quite often I take many class sessions to do Second Amendment. So as my time clicks on, doing that 2 decades of expertise on what I would say is also very telling, we are starting to call it gun rights when I was in law school, it would have been gun regulations. The AALS group that I'm a part of is the gun rights and regulations group instead of the gun regulations group. So the court is not only changing the law, but it's changing even how we think about these things. So to do this as efficiently as possible, I think it's helpful to have some of the facts, and I tried again because I don't want to take the 2-hour chunks that I usually do this in to make sure I had it written down. In Cargill, which some of you have heard of as a bump stock case, the issue is whether an ATF rule that deems semi-automatic rifles like an AR-15 to be machine guns when they have a rapid-fire conversion device called a bump stock. The archetype modern machine gun is the military standard issue M16 assault rifle. With an M16 in automatic mode, the shooter pulls the trigger once to achieve a fire rate of 700 to 950 rounds per minute. A rifle equipped with a bump stock can fire at a rate, would be a semi-automatic rifle, which is what an AR-15 is called. But when it is equipped with a bump stock, it can fire at a rate of between 400 to 800 rounds per minute. So that's what it is at issue, is whether the statutory definition of a machine gun, which also includes a reference to a device that makes a semi-automatic gun act like a machine gun, whether that was actually covers a bump stock. The 6-3 ruling by, I call them the 6 Republican-appointed justices. They are far too activist to be called conservative. I've never called them conservative, and they're not. But I will call them Republican-appointed, and they are a supermajority. And they concluded that a semi-automatic rifle equipped with the bump stock is not a machine gun because it does not fire more than one shot by a single function of the trigger. Why I am fascinated by that, it says a lot more about the court's methodology for interpreting federal statutes or statutes in general than it does about what the statute actually meant to Congress when they wrote it. The other case, though, Rahimi, which is what a lot of us were watching. I was watching Rahimi very closely. I think the best way to understand Rahimi is for me to start the way the court started, which was by telling you something about Jassy Rahimi. He's not a responsible gun owner. He's someone who grabbed his girlfriend by the wrist, dragged her to her car, shoved her in, struck her head against the dashboard. While a bystander saw this altercation, he went and got a gun and started shooting at, the court's not clear, either the girlfriend or the witness. After this parking lot incident, the domestic violence restraining order was put in place. He threatened a different woman with a gun and then had a spate of 5 additional shootings. They included things like exiting his vehicle after he collided with a car and proceeding to shoot at the other car, shooting his gun in the air while driving through a residential neighborhood, and then speeding down a highway when a truck flashed his lights at him. He fired several times at the truck and a car that was going by before he fled. And then finally, and I think oddly and bizarrely, he also, while dining at a roadside burger restaurant that, as someone who's in Con Law and has been watching the drip drip, it was a Whataburger restaurant, where his friend's credit card was declined, he pulled out a gun and shot into the air. So as my time clicks away or is gone, the court shouldn't get any brownie points for saying that this individual is subject to the restrictions of a federal statute that says when you're subject to a domestic violence restraining order and you've been found by a court to be a danger to another human being, you shouldn't get to keep your gun. What is much more striking, and is striking to me about reading Rahimi, is one that Justice Roberts' majority opinion is written so very narrowly that it tells you, to the extent we're looking forward, that they wanted to make sure this was only a Rahimi case. And so to put all those details in, this is not a court that puts in details about cases lightly. In many cases, they get the facts extremely wrong. What they did over and over in Rahimi was point out that this was someone that a court had found to be a danger to others. So that's narrowing what kinds of gun regulations we, the people, could have through our elected leaders, the power to put in place. People power is not what this court is interested in when it comes to gun regulations. And then they went so far as to say repeatedly, another reason this restriction was going to be okay, and this is why they managed to get 8 justices. They still couldn't convince. Why I had to read these facts is Justice Thomas still does not think this statute is consistent with the Second Amendment, which tells you how exceedingly high a bar he is willing to apply. But they said that the fact that it would only be a temporary restriction on Jassy Rahimi was also very important. So it was very difficult to read this case as anything other than a really continuation of what has been not just a raising of the bar with respect to gun regulations, but a complete shift as to whether gun regulations are presumptively constitutional, which is what they were when I was in law school, and I tell my students that, and they can't imagine. I'm like, that's why I didn't have to hide under my desk, and there were federal gun regulations. And now we don't just have a higher bar. We have a court that is doing something, and I'm going to move to something very wonky in con law, but very doctrinal, something that if any of you have gone to law school or been around law students, you've heard of standards of review and things like rational basis and strict scrutiny. This court went so far a day before Dobbs to say that means ends analysis, those kinds of standards are inapplicable to gun regulations, and put in place a historical analog test. And why I volunteered and why it's so consistent with what I think will help connect a lot of the cases that we're talking about today is that what both of these cases confirmed to me as I read them, including their concurring opinions, is that the thing that is most dangerous about this court is that we've got 6 justices who are heavily committed, deeply committed to what I can best label an anti-perpetivist methodology for interpreting both the Constitution and statutes. They do not care what James Madison thought the Second Amendment was supposed to mean, and they want you to think they care, but if you know it the way I know it, that's not what they're doing. And what they have done is created 2 methodologies that have completely empowered them to pretty much interpret words to mean whatever they want them to mean, and that a bump stock is not somehow a device that makes a semi-automatic rifle, which shoots plenty of bullets per minute already, isn't a machine gun. It is continuation of what I think we've seen this term is that this court, when you read across the cases, there is just a rank hypocrisy that you just can't avoid. So I'll stop after I know I went a little over, but at least I got time. So hopefully I ended about where everyone else did.
Thank you. And I'm going to want to come back to the group about the methodology, which I think is a very important point. But speaking of the court giving itself more power, let's turn to the democracy cases. We're told that democracy is on the ballot. Democracy was on the docket this term. Justin, tell us what the court did and why it matters.
So what the court did was put it back on the ballot, where it was, where it is, where it will be. And the court essentially told all of you that it's not coming to help you. So there were 3 cases about undermining democracy in different ways. And I parsed them a little bit as Kimberly did, in the sense that I feel differently about them as a law professor and as a constitutional law scholar than I do about them as a person in the world. These decisions, I think, were each wrong and each make my life hard, but I think this is surprising, matter less to everybody else, not on this stage. because I don't think they change the ground truth that we're all experiencing out in the world. They say a lot about methodology, they say a lot about interpretive approach, but I don't think they actually mean quite as much as the media would have you believe for their particular topics as they do about how the court thinks about law. So my life hard, your life pretty much the same, I think, unless you're a law professor or a lawyer. The three cases, one case, Fisher versus United States, about the January 6th violent armed domestic assault on the Capitol, the only one in our history. The Brits were the only one who invaded the Capitol before now. January 6th happened. A lot of people were charged with a lot of things. This case had to do with a particular statute, the Sarbanes-Oxley Act, put in effect after Enron for corporate fraud, about obstructing an official proceeding. The official proceeding in question, the counting of electoral votes on January 6th. And the court essentially said, that statute isn't made for this sort of thing. I have lots of thoughts about the interpretive methodology, but as a practical matter, there were virtually zero people charged with January 6th events who were only charged based on obstruction. That is, the court said, this statute can't be used for this sort of thing, but there are lots of other statutes that can be used for this sort of thing, that were used for this sort of thing. And I think that very few defendants will have convictions overturned or sentences even revised because they were also convicted of lots of other things, including assault, including trespass, including lots of other crimes associated with the 6th. So big deal for the law professors, maybe. Less of a deal, I think, for people interested in justice for those who assaulted the Capitol on the 6th. The second case, Trump versus Anderson, was about Colorado attempting to throw President Trump off of the primary ballot based on the finding that he engaged in insurrection. 14th Amendment to the Constitution says if you've engaged in insurrection, you can't be a candidate for office, for a whole bunch of offices. Lots of questions about exactly which offices and exactly when and exactly who finds out, and lots of questions about all of the context. And here too, I have real questions about the court's methodology. What they found was that effectively the 14th Amendment was meant to be a federal control on state misbehavior after the Civil War. Very plausible that the 14th Amendment was in fact meant as a federal control on state misbehavior, that it was not meant for one state to reach out to control federal officials, and that there had to be some federal engagement in a finding in order to kick someone off the ballot for having engaged in insurrection. I find fascinating, as a side note, we've had a federal finding that nobody recognizes. More than half of the House and more than half of the Senate found as a matter of fact that former President Donald Trump engaged in insurrection and should not be entitled to hold office again. That's what happened in the second impeachment. It's just that they did it with a threshold of 2/3, and so it didn't have meaningful legal effect in the context of an impeachment. But that is a notable and weird finding. We don't usually get half of Congress to say that someone is ineligible to hold office again. The court said Colorado, in this case, can't make that finding all on its own. Colorado can't act unilaterally to throw President Trump off of the ballot. Again, big deal for law professors, big deal for interpretation. As a practical matter, I don't think there's any state where Donald Trump could have won that was going to throw him off of the ballot. And so as a practical matter, I don't think it mattered to this fall. That brings us to the immunity case that came down, that everybody was waiting for, that came down on the very last day of the term, Trump versus United States, about whether presidents can be charged with criminal offenses. Oh boy. So I think that it's contrary. The opinion they said is maybe. So you're welcome. The court said maybe. The court said it's going to take us a long time. It's going to take a lot of people a long time to sort out. We'll come back to it. Lots of other courts have to come back to it. For some stuff, no. For some stuff, yes. For some stuff, maybe. The opinion, I think, runs contrary to the direct text of the impeachment clause itself. runs contrary to the direct text of the Constitution. It's not very historical. It is way off on constitutional theory, turns the separation of powers upside down. Separation of powers about ambition, checking ambition, and other branches regulating behavior, and actually says, no, we have to protect this one branch at the expense of all the others. In addition to all that, it imagines a presidency that it has to encourage to run up to the line of criminal behavior because we don't want to deter potentially criminal behavior. I want to deter potentially criminal behavior. This is all invented doctrine. It doesn't show up anywhere. It's entirely functional and not in line with any of the methodologies from any of these other cases that we've discussed so far. I have real sympathies for the civil immunity corollary, right? I can understand actually wanting to protect the president from civil suits. I think they're very different contexts in the criminal case. And I think people were looking for something different out of this case than what they should have been looking for. And so this is where I think that even this case matters a little bit less than you all think it might. It's a big deal for constitutional law professors and a big deal for lawyers. But most people committing, for example, bank robbery, don't walk into a bank, hold a gun up to the teller, demand all the money, and then walk outside and hold a press conference saying, I just walked into the bank, held the gun up to the teller, and demanded all the money. Most criminal trials attempt to come to resolution and closure through some sort of, and we're trained through this by TV, who done it, or if not who done it, at least what did they do? That's not what this is. All of the facts in the DC case, the January 6th case about undermining the election are and have been known for some time. Some were public at the time, some came out through later reporting. And I think people were looking for closure from this criminal trial, which they won't get until well after the election, if ever, in part because they didn't want to make the assessment themselves. But we have all the information that we need to make an assessment of accountability based on the facts that would have come out in the January 6th case, in the DC case. And so I think people looking for the court to make a decision so that we could have a criminal trial were actually asking to be absolved by a jury of 12 for what effectively becomes a decision by a jury of about 150 million. It's up to us. And the court said crystal clear, it's up to us. If you don't want a despot in office, don't put a despot in office. That was always our choice. And so I think the legal impact on the public may matter less than how we're going to teach this case in generations of con law classes going forward.
I have a lot to say about that, but
Me too.
But before we
Even though he kept the time for me, I have a lot to say about that.
Before we get there, though, I want to take a minute. We were supposed to be joined by one other panelist who is ill tonight, who's going to talk about the administrative law cases, which are another huge headline. So Carrie has volunteered to just very briefly talk about one of the, I'd say, 4 big administrative law cases called Loper-Bright, and then we'll get into a little bit of discussion.
All right, I'm going to say the opposite of what Justin was just saying. I think unlike the immunity case, this stuff doesn't get the big headlines. This was introduced tonight as not super sexy. This is very sexy. You should all be paying attention to it. It doesn't get the same amount of coverage, but it is so important, right? It is super important to your everyday lives, and people understandably do not understand this. So I'm going to try briefly to say that starting in the 1930s, we began to create in this country the administrative state. Before I went to law school, I didn't even know what that was. Maybe you do because of all the coverage. But the administrative state is all the administrative agencies in the executive branch that regulate everything. After the Industrial Revolution, the technological revolution, we had a lot more complicated science, a lot more complicated transportation, a lot more complicated society, and we needed a lot more administrative agencies. Department of Transportation, Department of Education, the SEC, the EPA, all those alphabets agencies that you hear about, they have ballooned to be a massive part of what does the governing in this country. They didn't exist at the founding. It's one of the biggest changes in United States history that we created all of these administrative agencies that really regulate your day-to-day lives. How much lead can be in the paint, how clean your drinking water has to be, what schools have to teach, on and on and on, every aspect of our lives. And they are filled with experts and scientists and people who understand the various questions that they face. Okay, Congress delegates the authority to the agencies to regulate various areas of life. Congress cannot write statutes that are perfectly detailed and perfectly unambiguous. So there's gaps in the statutes and there's ambiguities in the statute. When Congress says, okay, EPA, you can regulate clean water. But they don't spell out every single thing. So what the court decided in the 1980s in a case called Chevron is that we will defer to administrative agencies when they interpret the gaps and the ambiguities in these statutes. Right? These are the experts. They're trained to figure out what it means. They interpret the statutes. And the courts are not going to second guess the experts unless they're being totally arbitrary and capricious. And the court ultimately holds the ability to do that, but they're going to defer. So we've had decades and decades and decades of courts deferring to agencies on these questions. We've also had decades and decades and decades of a resurgent conservative movement or Republican movement, however you want to call it, that has had deregulation at the heart of what it cares about. And I really think if you talk to the Koch brothers or Harlan Crow or any of the folks who are in the news for different reasons, about what they care. They may have views on affirmative action. They may have views on abortion. But what they really care about is deregulation. They do not like the EPA, right? That is the core of a lot of the movement that has swept into power, certainly in the judicial branch of government. And so it was ripe for a challenge of Chevron that reached the court this term in a case called Loper-Bright. And the court overruled Chevron. That is a big statement right there. The court said that we get to say what the law is. We are not going to defer to agencies. We're not going to defer to agency expertise. We are going to be the deciders of what all these statutes mean. We don't yet know how often the court will exercise that power, but it is a massive power. It is an absolutely massive power that the court has now arrogated to itself. The dissent said this could destroy, it could wreak havoc, it could destroy the entire system of government in the United States. We don't know if that's going to happen. The court certainly has the power to do that. The dissenter said, we are not scientists, we are not, Elena Kagan said, these questions are like, is an alpha amino acid protein a polymer? And then she said, what even is an alpha amino acid protein? We're lawyers, we don't know any of this stuff, we should not be deciding it. The scientists should be deciding these questions. I can't resist saying this is also the term in which Neil Gorsuch wrote an opinion in an environmental law case where he talked through the entire opinion about nitrous oxide, when what he meant was nitrogen oxide, the dangerous chemical, not the laughing gas that you might get at the dentist. But he didn't know, and none of the other justices and their clerks and everyone who read that opinion didn't know the difference between those chemicals. And fair enough, they're not trained in that. It doesn't, please, if you're interested, watch the development of this over the next years. How much will the court use this big new power to countermand the administrative state and agency actions that it doesn't like? Stay tuned for that.
Yeah, and I'll just add a very brief note about another case the court decided that's even more in the weeds. It's a case called Jassy, and it involves whether or not administrative agencies can engage in court-like activities. They can have an administrative judge make a determination and dole out some fines and things like that. And the court made it very hard for the agencies to do that and said, no, the agency has to take people they think have committed infractions of these rules to court. And that change is going to be very large as well, because the agencies they're not set up to be able to litigate all of these things in court. And you combine that with 2 other cases the court decided, it's definitely pushing back on the questions of the administrative state.
I think a lot of the cases you see have court centralization at the core. This is the term where in a lot of different areas, as Kimberly said, we look across lines and we see the court saying, no, that's my role. A lot.
And you say court centralization. I say a power grab of the Supreme Court that usurps the power of the legislative and executive branches.
So I think it makes perfect sense for people to criticize the Supreme Court. I'm all in favor of that. I wonder if it might be a useful experiment for each of us for every one of the opinions we criticize. In my case, I didn't criticize, but I kind of endorsed it, so I'll be happy to do the opposite, to come up with the strongest argument on the other side. Obviously, somebody thought that there were good arguments. In the January 6th criminal prosecution cases, one of those somebodies was Justice Jackson, not exactly a Trump partisan, right? Mm-hmm. The Jassy case, I mean, I think there was a constitutional claim, right, about a constitutional amendment we haven't mentioned. I mean, would it make sense for each of us to just say a word about what would be the strongest argument? We may disagree with it. What would be the strongest argument on the other side?
In each of the cases that we've
each of the
talked
cases,
about.
yeah,
I don't know if people want to engage in that exercise, but what I can do
Well,
is,
I'd be happy to do it for you
Yes,
folks
go-
if you'd like.
Give it a try.
I mean, for starters, so Jassy is an excellent example. You could say it's a judicial power grab. You could also say that the Constitution says in the 7th Amendment that in civil cases at law, generally understood as not including injunction cases or admiralty cases involving things on the high seas, there shall be a civil jury trial. So the court said, possibly incorrectly, but I think not ridiculously, that means that if I sue you, you can't be forced to pay money to me unless a jury actually does this. Not a judge, not an administrative agency. There's got to be a jury. Before your money is taken, there's got to be a jury that says, yes, you're liable. So in Jassy, the court said, well, because there is a 7th Amendment, there needs to be a jury in this kind of situation. That means a jury within the judicial process. If it's a power grab, it's a power grab that the Bill of Rights sets forth by reserving certain power to federal juries, which is to say to ordinary citizens, rather than judges, which is what what the framers were contemplating, but perhaps rather than administrative agencies, right? I mean, that's not a ridiculous position. Maybe it's wrong, but it's not ridiculous.
And I can...
Oh, go ahead.
Right, Carrie.
I was going to go ahead and say what you would be concerned about. Why? I mean, there's absolutely a cogent argument that you do not want the executive branch making law. They're not supposed to. And to delegate lawmaking authority to, as I think it was Justice Alito, but it could have been Gorsuch, the demonized administrative state minions who sit in D.C. and do things to make everyone's life worse, which is a policy view, right? Like if you like those minions, you're like, I sent their boss to D.C. to appoint them to all these subparts of the various departments, and whether that's the Department of Justice or the EPA. And so we definitely should be I'll just go ahead to where I was going to go. What did I say I was up all night about when it was 2018? Autocracy. I don't want power centralized in any of the branches of the government. Neither did the framers. It is a very delicate balance. So we can be tyrannized by the administrative state. We can be tyrannized by the Supreme Court. We can be tyrannized by the executive branch. And Congress was purposely put in the Constitution to not be able to tyrannize us very quickly or efficiently. So, they might
They've
be the
achieved that one.
Yeah, so they don't get things done that quickly, but that's also on purpose. So I could very easily make lots of arguments as to why we don't want people who are not our elective legislators making policy. And I think at the heart of it, the critique of Chevron is that it is the court backing away from doing its job of interpreting statutes and regulations and letting, again, I don't imagine these people to all be evil minions. I want my water to be clean, so I'm kind of glad if they know the chemical compounds, they can know what's going to kill me and what won't. But I think that Carrie is making an excellent point, and where I want to jump off the train of saying that, we all should care about our liberty. So I don't want anybody getting too much power. So it's not just reserved for the court. But where I think we need to absolutely take note is that if this court loses all legitimacy, it can't protect us from autocracy, whether that's an autocratic President Trump, which since he's promised to be one, the odds of him being an autocrat are higher than other presidents. But I think Thomas Jefferson was very concerned that someone who didn't look like an autocrat, so that's where I would take issue, Justin, is that the framers imagined people who would look very reasonable and then become autocrats in office. And so I need a Supreme Court that has both the legitimacy and the ability to know what the framers' purpose in writing that Constitution was, and it was for no one to be our king. And the fact that everybody woke up that morning and didn't hear that from the court, I think that matters a lot. I mean, we can go vote and do what we can, but the Supreme Court's legitimacy is at stake. And I don't say these words lightly. We need the court to have legitimacy.
I want to come to Carrie, and I want to. I know you had thoughts about not the holding in the Rahimi gun case, but about the methodology. What is going on with the court? Are they being consistent in how they're understanding how to read the Constitution? We heard from Justin that there was no methodology in the immunity case. There was a very different kind of history and tradition methodology going on in the gun cases. Can you give us kind of a broader perspective on this?
Yeah, so in 2022, within 2 days, the court decided Bruen and the court decided Dobbs. And that was a gun case and an abortion case. And in both of those cases, the court said, we're replacing the test that we've used in the past with a new test. It's going to be the history and tradition test. And we're going to use this now in a lot of constitutional areas. And what the history and tradition test says is, we are going to judge the constitutionality of a current regulation based on whether it is deeply rooted in our history and traditions, very specifically defined. And that is the only way that we can legitimately and objectively say what the law is and not be judges inserting our own policy views. We're going to look to see whether that right was deeply rooted in American history and tradition, where the American people have viewed that as a constitutionally protected liberty or right. And that we're umpires, right? We're not even going to engage in that much judging. We're going to look to see what the people of the past thought. So in the gun context now, the rule is every time a level of government, a state or the federal government passes a gun regulation, or indeed existing gun regulations, the question is that a gun regulation that has existed throughout American history and tradition? Now, a lot of the times the answer is no, because we have a million new kinds of guns and a million new kinds of gun regulations. And was there a domestic violence prohibitor at the time of the founding? Was there a law that said if you are convicted of domestic violence and you're under a domestic violence restraining order, you can't have a gun? No, there wasn't. So the question becomes, in all of these cases, now the court is saying we're looking for a historical analog, and only gun regulations that have a historical analog are constitutional. If it doesn't have a historical analog, we're going to mow it down. And they've mowed down a bunch. But then Rahimi comes to the court. And Rahimi, as Kimberly articulated, he's not a good guy. Supreme Court justices don't like him, and they're not particularly enthused about people who are shooting and terrorizing people having guns. But they articulated a test that said the only regulations that are constitutional are the ones that are deeply rooted in history and tradition. This regulation did not exist 200 years ago. So what do? Well, what the court did in Rahimi is said, well, it doesn't have to be the exact twin. If it's an analog, like it's close enough.
It's a cousin?
Yeah, like maybe a cousin second. I mean, the dissenters were joking about this, which is how close a relative does it have to be to exist today? And in that case, they found that these are the kinds of folks that they wouldn't have liked to have guns at the time in the founding. So even back then, they didn't have this law. This is the kind of thing they would have. Now, you could agree with that or not agree with. My problem with that, my problem with the history and tradition test more generally is that is such a malleable, flexible test that any judge can just I, in fact, wrote an article that I published last spring saying that they were going to uphold the gun law in Rahimi, unlike all the other gun laws that they're mowing down, because they don't like these folks and because it's so easy to be outcome determinative, because you can say something is or is not like, because it's a matter of degree. It's particularly galling that the court sells the history and tradition test as an objective test where judges are stepping out of judging. Now, I happen to believe that constitutional law doesn't permit that. You have to judge. You have to engage in judging. Politics is inextricably intertwined with a lot of big constitutional questions about what equality means and what liberty means. And anyone who tells you that this test or that test, originalism, textualism, history and tradition, is going to allow judges to get out of the game of judging is selling you a bill of goods, and in my mind is dangerous because they are taking a lot of power that I would prefer remain with the elected branches, and that you all get to decide what the gun regulations are going to be, not 5 unelected people in DC, but that is currently where we are.
Eugene, I want to give you a chance to. I'd like you specifically to reflect on whether you think the court was being consistent.
Sure. So I think there are a couple of questions that arise. The first question is, what rights does the Constitution secure? So some people think that, in fact, when the Constitution talks about the right to keep and bear arms, it is actually just a right of states or of militias or whatever else. Or for other reasons, we should read it as not securing that right. That's a plausible debate. It was had on the court in 2008. It continues to be had. It's an interesting question. But the court has said that it does indeed secure an individual right to keep and bear arms, and there is actually a lot of history and tradition supporting that. Now, so there is, of course, the question of whether you want to leave things to the democratic process, to the political process, or to judges. And I think in Dobbs and in Bruin, the court reached 2 different results because it thought that the Constitution does secure a right to bear arms, but does not secure a right to abortion. Because it doesn't secure a right to abortion, it said we should leave this to the political process. We should leave this to elected officials. Because the court concluded that it does secure the right to keep and bear arms, at least arms are mentioned in the Constitution, then it said, well, at that point, given that it's part of the Bill of Rights, the consistent thing to do is not to leave this to the political process, just like we don't leave the First Amendment and the Fourth and the Fifth, or the Third if this actually came up. So I think that is consistent. Now, you might say the court got it wrong, that the rightly read the Constitution, even though it doesn't mention abortion, should be seen as protecting abortion rights. And rightly read the Constitution, though it mentions right of the people to keep and bear arms, it isn't really the people like you and me, it's state officials or state agents and such. You could say that, but that's an interesting question. Once the court concludes that, I think not implausibly, the Second Amendment does secure a right, an individual right, and that the Constitution does not secure a right to an abortion, then it's consistent to say, yes, it's part of the Bill of Rights, we take it away from the political process. Now then the question is, do we go through and try to history and tradition approach, or do we apply like a strict scrutiny or intermediate scrutiny, if you've heard this means ends analysis? Really hard to characterize in a lay sense. So let me set that aside for a moment. And the answer is it's impossible for the court to be fully consistent because the court, including both liberals and conservatives on the court, have actually used both approaches in different contexts. So in the free speech context, indeed, there is the strict scrutiny, which is really very demanding test. There's intermediate scrutiny and such. But let's look at some other rights. Jury trial, criminal jury trial. Let's say the government says, criminal juries, make it just too hard to convict people of certain things. Like in certain states, it would be too hard to convict people of hate crimes through criminal juries because there are too many racists on the juries. So what we're going to do is we're going to say there's a compelling interest in enforcing the law, so we're going to waive jury trial right in this kind of situation. Or in other states, it's too hard to convict drug offenders, so we're going to essentially waive the jury trial because there's a compelling interest and it passes strict scrutiny. I think our answer would be no. The Constitution says jury trial, not just jury trial in some cases, jury trial in criminal cases generally. Now, maybe there is a history and tradition of very petty offenses. Rightly or wrongly, the court held this back in the 1930s, that there's a history and tradition of if the crime essentially is punishable by 6 months or less in jail, that there a jury trial is not required. So yes, if history and tradition authorizes it, that's fine. But to look at a recent case, which was, I think, conservatives and I think a conservative liberal coalition, but lopsidedly, I think, if I recall correctly, in favor of the jury trial right. They said you have to have unanimous juries. The Constitution doesn't say unanimous juries, but the history and tradition is of unanimous juries. So even though the democratic process in Louisiana and Oregon led to non-unanimous juries, that's not permissible. I can give you other examples. The Confrontation Clause, another situation where both conservative and liberal justices have, with some conservatives and liberals in dissent, have said, look, you have a right to confront witnesses against you, and that's not something that can be relaxed just because there's some exception under state law for hearsay evidence and so on and so forth. Can't be relaxed just under heightened scrutiny. The privilege against self-incrimination. Even if you say, well, there's a compelling interest in enforcing the law, and it's narrowly tailored to that interest to require people to testify against themselves, well, the Fifth Amendment says otherwise. So what the court did in Bruin, when it said history and tradition in Second Amendment cases, said we're going to treat the Second Amendment kind of like we treat the Fifth Amendment and the Sixth Amendment. Now, maybe, in fact, those amendments should have been read more broadly, but at least similarly in that we're not going to allow the government to trump the right through some sufficiently compelling interest. Any exceptions have to be recognized as a matter of history and tradition. I vastly oversimplify because, in fact, you can't be consistent even with those cases because there's some differences in between them. But I think that's, if you had to defend the rahimi majority's position, it seems to me that would be at least a plausible argument they could make.
We could go on for a few hours about this, I'm sure. I want to ask one last set of questions. I'm going to start with Justin and work my way down. Please keep your answers brief, and then we're going to turn to the audience. What's going on with John Roberts? How do we understand the current Supreme Court, which is under, as a few of you have mentioned, under this pressure? There have been ethics issues that have come up. The court puts out this ethics code that is self-enforced by each justice. Roberts was seen as someone who cared about the institution, and yet there were a lot more 6-3 decisions dividing along ideological lines. Is something changing?
Yeah, that was a long time ago. I think what's happened to Justice Roberts is he's finally calling balls and strikes. It's the perfect analogy. Anybody who's played baseball or watched baseball knows that the umpire's in complete control. They set the strike zone, and they decide in advance where strikes and balls are going to be called, and then you're playing by their rules. I think he's lost his hold on a majority. He is clinging to where the rest of the court is going, and he's hoping to act as a sea anchor a little bit in slowing down a runaway train that he no longer has any control of. I think you've seen that in this last term. To the extent that he's an institutionalist, that horse is well out of the barn. And to the extent that it is now transparent, I think, that the court is making decisions based on policy preferences that it casts as historically determinative. Roberts would love to hide that more. He'd love to shift the strike zone ever so slightly in one direction or another. But now he's being forced to show his hand in saying, I'm deciding that thing that you all thought was a strike, that's actually a ball.
Kimberly?
I'm trying to put a succinct point on where the court's rank hypocrisy really stems from, because that's not something I said in 2018. It's not something I said before 2022, and maybe not something I would have said before I read all the concurring opinions in Rahimi, including Justice Kavanaugh's, where he was giving the most pompous lectures about the most basic things in constitutional law, which is judges should not decide matters based on policy preference. And what I think is at the heart of the rank hypocrisy is that the takeover of the court by 6 justices who are proponents of original meaning originalism is not something that's just been happening in classrooms and with legal scholars reading. It has been a massive media campaign, marketing campaign, where most people think they actually care about the specific intent of those who wrote the words. And I have to spend about 5 weeks in my originalism class to teach my students, like, no, right here he says he doesn't care that James Madison actually was talking about militia. That's all he was talking about. Scalia was like, no, it's a pre-existing right, and let's pull out some old history things, and let's pull out dictionaries. And it is all, our rights are being stolen from us, not earnestly, not objectively. And one of my con law professor at Yale was a man, Joe Goldstein, and he wrote the tiniest little book called The Intelligible Constitution. And what it said was that Supreme Court owed us a duty that we could understand their opinions and that they be honest and forthright. And what's not honest and forthright about historical analog, original meaning, originalism, any of those things is it's not a real methodology. When you read all the concurring opinions, Justice Barrett says, I don't think you should be able to use post-ratification history. And by that point, I'm always talking about my non-lawyer cousin at the 4th of July barbecue. They have walked away. They're like, what the heck are you talking about? But it really matters that they cannot agree amongst themselves as to which historical sources they should use, but yet will preach that Brown v. Board of Education was based on policy preferences, and let's get all indignant. And so I think that a lot of the things we're saying, they can all be true at the same time. But I would just say that for anyone who really cares about this and wants to know that the superpower of the people who are taking our rights is decontextualization. If they start talking about things out of context, someone's womb being regulated the same way as an AR-15 with a bump stock, then think about that. Should your neighbor be able to regulate your womb? And if you read across cases, Justice Roberts has said your neighbor and your congressman shouldn't be able to tell you to eat broccoli. So why in the world should they be able to tell you need to stay pregnant? Like, make that make sense to me. The word liberty in the due process clause should definitely include your physical liberty and include your womb. So that's why I think we're in a very different time.
Eugene and then Carrie, and let's try and keep
Sure.
these brief so we can get to the
Sure.
audience.
So we've heard about the importance of the court maintaining confidence, the trust of the American people, and of course it could lose the trust of the American people because it really does things that are labeled dishonest, that are hypocritical, that are stealing our rights, or it could be that people are trying to diminish the trust of the American people in the court, perhaps unjustifiably. So that's an interesting question. That's why I thought it would be nice to see, like, what would be the strongest arguments? Like, if Justice Roberts were here to talk about broccoli, he'd say, well, I don't think Congress has the power to tell us to eat broccoli because that's not a job for Congress. But states, much as we might dislike it, much as that we think the political process would preclude that, can indeed tell us what to eat and what not to eat. California, for example, tells us that we can't eat, or at least we can't commercially buy foie gras. This is for animal rights reasons, or we cannot consume certain kinds of drugs, right? So I think that some of these explanations may not be a matter of hypocrisy, but may be a matter of distinctions that at least are plausible distinctions that people are trying to fudge. Or fudge. By fudge, I simply mean are glossing over distinctions that I think really ought to be made if we were trying to focus on things. Now, just to answer your question about Roberts, I think conventional wisdom is right. There are 3 coalitions on the court. There is a quite conservative coalition of Thomas, Alito, and Gorsuch. There is a quite liberal coalition of Sotomayor, Kagan, and Jackson, and there's a moderate conservative coalition of Roberts, Barrett, and Kavanaugh. Sometimes they go one way, sometimes they go another way. Being moderate conservatives, they more often go the conservative way, but that's probably, to answer your question about Roberts, that's where he is. And it's true he doesn't control things, but he's not supposed to. He just has one vote like everybody else.
Carrie.
Yeah, so I disagree with that characterization of the court. I think these 6 justices are among the most conservative justices in all of recorded history, and they are certainly in the modern era, and they are, moderate is not the right term to use for those folks. I just want to, I am not endorsing this view. I am just want to leave you with something to think about, and it is a counterpoint to what Kimberly was saying. She was making the claim, the case that we need legitimacy in the Supreme Court. There are increasing numbers of constitutional law people that I associate with who are arguing the exact opposite, that people need to stop granting the Supreme Court so much deference and so much legitimacy, and actually realize that throughout American history, except for a very brief period in the Warren Court era, where the court stepped in to protect civil rights and vulnerable people and the people whose voices weren't heard, the vast majority of the time, the Supreme Court has protected the elites and the people at the top. They come from that, they protect that. That has been their role in American history and in our democracy, and we all need to stop being so deferential and respectful of a court that is out of control and that is reverting to what actually has been the norm, which is protecting elites. The Constitution has all sorts of ways in which Congress can try to rein in some of that power, including increasing the number of justices on the court, which has been done in our history, and jurisdiction stripping. The Congress has the ability to take certain questions out of the court's bailiwick. This is not something Joe Biden is interested in doing. He just will not listen to it. He doesn't want to go that way. He said we can't get into increasing the number of justices because that could politicize the court. Right. So I actually engage in endless conversations about this, and I am really not out here advocating that. I don't actually know what I think about all of this yet. But I do want to say that you should think about, do we need to be more differential and respectful and talk about the legitimacy of the court? Or do we need to say, you know what, we the people are the ones who actually control. We need to think about ways to get power away from the court and give it back to the elected branches.
Okay, we've got about 10 minutes for questions, and I really need you in the audience to keep them short and keep them questions.
Hello. Question for over here, keeping it short. We heard a little bit of something about expanding the number of judges that we have. What do you guys think about term limits? And also, just because of, if you want to answer it, fine. If you don't want to answer it, fine. How does the Supreme Court work on things like antitrust laws and stuff like that? I mean, which is something I didn't hear too much about today, and I don't know if it's applicable. So those are the 2 questions.
I think let's keep it to the term limits question, just because I don't think any of us have the antitrust expertise on here. Thoughts about term limits?
Well, I wanted to say that court reform, which is a very legitimate project for the legislative and executive branches, is something that is only possible if the American public elects enough people to Congress to pass that kind of law. And that when FDR proposed court reform, in his view, and then his opponents called it court packing, and a lot of law professors brought the whole project down, he was only able to do that because he had a massive majority in both the House and the Senate. So when I've been asked, hey, should Joe Biden pack the court? My response is, how in the heck would Joe Biden pack the court unless he's a king, right? He can't do it.
Well, he is now.
And maybe it'll all work out that way. We know, but that's what makes it hypocritical because we all know that only goes one way. And that if Joe Biden goes off and uses SEAL Team 6 to kill Donald Trump, we don't think he's going to be free of prosecution. But so that would be the answer with term limits, that you need exactly what Carrie's saying. You need a groundswell of Americans to want that so badly. They will send not just 51, you need a massive majority, because when it's been tried before, it failed. And a lot of it was because people like us would sit on the dais and we'd go, it's terrifying. Because it is terrifying. Once you start packing the court, there is absolutely no question that then it becomes something that politically it could happen again. But at the same time, Carrie's saying it's time to break glass in case of emergency. So I'm just saying that it needs to be put back on the voters to recognize that most of the things we talk about can only be operationalized if it is the will of the people. And so at this point, I think term limits is certainly constitutional, but I don't know if there's enough political will to send enough people to Congress to do it.
The reason I focused on jurisdiction stripping and increasing the number of justices is there's a debate about whether we can actually do. Article 3 judges are appointed for life tenure. So there is some real serious question about whether it would be constitutional to put in term limits on those justices.
So they're appointed to Article 3 courts for life, but nothing says they got to be Supreme Court justices for life. And if enough of you want it, this is the thing, you all change how law works. And part of this is recognizing your own agency in this. If enough people stand up and say, no, the Article 3 system we want is for a rotating cast of characters on the Supreme Court, you can have it.
And you
That's
can
how that
also
works.
amend the Constitution. That's also something. If enough Americans wanted to make the Second Amendment more clear, that could also be done. And the same with the immunity decision. But so it is kind of the time in the night to turn it back to the people.
So I do think it would take a constitutional amendment in a way that court packing wouldn't. But here's the difference. Court packing, whenever it's proposed, is obviously an attempt of one political side to capture the branch. You may like that side, you may want them to do it, but you've got to acknowledge that's what it is, and that's why the other side will disagree, and some in the middle will disagree. That's what happened during the Roosevelt term. That's what the talk would be if Biden were to do it. Here's a test. Imagine somebody were to say, yes, absolutely, there ought to be 5 extra justices on the court, or 6 extra justices, but it should be appointed by the next president. What would be your first question? Who's the next president going to be, right? The advantage of term limits, it seems to me, and possibly also court packing, if you really just, not court packing increasing, if you really just think that there are too few justices. The advantage of term limits is you can say, look, there will be 18-year term limits staggered every 2 years so that every presidential term gets 2 appointments, and it's going to happen effective 2044. Sometime where we don't know who's going to be in charge. We don't know whom is going to benefit. If we really thought that, and I do think that term limits are a very good idea for a variety of reasons. We could do that. But what you want is Team Blue to win or Team Red to win. Then yes, that becomes a lot harder because Team Red or Team Blue is going to fight back against this. That's what I like about term limits, is it could be set up as a genuinely nonpartisan thing. Court packing is not genuinely nonpartisan.
Let's go to another question.
Hi, hello. I'm a recent graduate. This question back here. This question is more.
We can't see any of you.
You're the voice from above.
Good to hear. Good to hear. This question is of the same tenor as that one about the balance of power between the different branches of government, but it's more related to Chevron deference and the overturning of that doctrine. If I'm not mistaken, when Andrew Jackson was president, there was some case that came to the Supreme Court that was decided against what he wanted, and he said something to the effect of, we have seen the court has made their decision, now let us watch them enforce it, which was definitely a tyrannical move to not care about what they said, but it's been the case since Reagan got elected that the administrative state kind of either is turned on or turned off, dependent on who the president appoints to certain agencies. We were seeing that in the Trump administration, where the head of the EPA was very uninterested in regulation. Is Chevron deference the sort of thing that you think really will totally overturn the powers of the administrative state, or does it simply give more credence to conservative ideas that the administrative state has no right to be, and thus it is not an umbrage of presidential power to let it go neglected?
So, is Chevron going to make a difference?
Maybe. When the court wants it to, yes. And that's the biggest danger. So here's the thing. There are too many unresolved questions of statutory interpretation and administrative law for the court to take them all. They just can't. They take 60 cases a year, 80 cases when they're really busy. It's going down, so they all want longer summer vacations. Lower courts can't take all of these cases either. So where they're going to find it convenient to defer to administrative agencies, or where they think that Congress is given special latitude, they will. And where they have particular interest in deciding what the law means, they won't. And it's the picking of those issues. The court sets its own docket. It's the same answer to antitrust. When the court wants a case, it'll take it. So when the court wants to do away with an administrative rule, it will all of a sudden decide that there is an ambiguity in the statute that it and it alone has to resolve.
We'll take one more question.
In
We did.
constitutional
I think all of us
law.
did.
That's not a hypothetical.
Yeah. Exactly. And you're in constitutional law, and you had a question proposing what was before the Supreme Court in the presidential immunity case, and you got that opinion. Would you have even considered passing that student?
If they could write that much in 3 hours, I'd give them an A.
No, I would say my students had they didn't come to my class, so I would say it would definitely not be anything close to an A. I would have given it an F. I'll jump out there.
So,
Out of law school if I'd written that.
right. So this is not my field, so I wouldn't be grading the exam. My guess is of the law professors who would grade these exams, probably 90% are going to be split loosely on the left, 10% on the right. That's kind of how my sense of the legal academy is. I think at UCLA, our law school, now that I'm retired, do we have one conservative on the faculty? Maybe 1.5. So if we're going to be realist about the court and say, well, the court is making decisions based on the ideology, which in part it is, because it's human nature, they're humans, and the decisions that they get are often ones which is not like there's binding precedent that resolves it. There is a lot of latitude. If we're going to be realist about that, let's be realist about questions we ask about law professors. So if you ask a group of law professors who are on the left, they're probably going to have, just being human, are going to have a particular view of results on the right. And vice versa. If you could find law professors on the right and ask them about opinion on the left, their being human would be influenced by that.
So Eugene, you're saying that the notion that a president can commit crimes and those to be official acts is something that is a partisan issue? Because that's why I am so distraught, because I thought there were things that were nonpartisan. And that's how I start my constitutional law class, which is the framers did not want a king. Like, to me, that's an empirical reality. It's not a partisan view, which is why I answered the way I did, because I teach my students that's not what our Constitution means. So that's why it would get a bad grade, because you didn't come to the beginning of my class. So I take offense at you dividing constitutional law professors based on our politics. We all have politics, but there should be some core principles about America. And I thought at a minimum it was that no man, including the president, is above the law. So are you saying that you think the Republican Party has a different view on that, or people who are liberal and conservative have different views on that? No, it's a question. I'm sorry. I actually want to know the answer, because it's just too easy to say it's partisan.
I would be happy to agree, as would all 9 justices, that the president is not a king. There's no doubt that the president is not a king. One reason is that he is elected. Most kings are not. There have been some exceptions. Another reason is that he stands for re-election after 4 years. Most kings don't. Another is that he can be impeached, which, in fact, may be actually true for the King of England. It's an interesting question. When they beheaded Charles I, I'm not sure it was exactly an impeachment, although it was actually a criminal trial. So maybe that would be an interesting analog. So I don't think the president is not a king is the right analysis. What is the right analysis would actually require, in my view, reading a lot of precedents, which I haven't, because this is not my corner of constitutional law. It would be interesting to see. It's possible that all 6 justices are just such idiots that they should have been failed out of law school at the outset. It's possible. It's possible. It's possible that they're not idiots.
They're not idiots.
So it's possible that there are awful people who are just trying to take away your rights. It's possible they're just a bunch of hypocrites. All of that is possible, which is in fact what all the conservatives were saying about the liberal justices, or the Democratic justices, if you prefer, on the Warren Court, right?
Democratically appointed.
That
decided Brown versus Board of Education.
Right, about the Warren Court and about Miranda and lots of other cases that were understandably controversial. It's also possible that actually they may have a plausible point. And I'm not willing to dismiss that, again, not being an expert on the subject, simply by saying the president is not a king.
We can't take more audience time. I'll briefly come to Justin, and then I want to end with Carrie on an important case that's coming next term.
There are so many. So all I wanted to say is that Eugene is right, they're not idiots. And also, there is no precedent for the immunity decision. This is literally the first time we have ever confronted this question. And it is very revealing, because this case brings you back to first principles, because there's nothing else there.
What about U.S. versus Nixon?
We had all kinds of discussions on evidence not about prosecuting the president. We had all kinds of discussion on civil cases.
But I think the reasoning was pretty clear that if it was a crime, it was going to be a bigger problem than if it were. I mean, I'm just saying, I think it's incorrect to say there's no precedent.
I am not persuaded by the reasoning, but in law school, we can teach you analogical reasoning. Part of the problem I have with so many of the cases from this term is the analogies can be bent to shape your view of policy. An orange is like a life preserver in that they're both orange. But I know if the boat's going down, which one I want to take with me. And if the question is taste, I have real questions if you think that they're similar. You can analogize to a lot of different things. And what these opinions do, and particularly the immunity opinions do, is I think they force you to watch the justices' reasoning from first principles. I have deep disagreements with where the court came out about what those first principles are and should be. But I think Eugene's right. This case in particular is uniquely revealing because there's no hiding behind precedent. This is where the court wants the balance of power to fall, writing on a clean slate.
Well, there's so much we've had to leave on the table, including the Grants Pass case about the rights of the homeless, many other very important cases. But before we go, I just want to come to Carrie about one important case that's coming next term. Scrimetti, if you could tell us.
Yeah, I hope we'll see you all next summer. So the Supreme Court is just starting to take cases for the next term, and they've taken one big one called Scrimetti. I'm sure you have seen there is sweeping the nation. Anti-transgender laws, something like 500. Every year there are more than the year previously. We've had something like 500 anti-trans bills introduced in the states, and a number of them have passed, including, very controversially, the bans on hormone therapy and gender-affirming care of various kinds. That is now coming to the Supreme Court. So Tennessee passed a law that bans gender-affirming care for minors. It bans puberty blockers, it bans hormone therapy, and it bans gender-affirming surgery. The Supreme Court has taken a case called Scrimetti. Surgery is not at issue in the case. What is at issue in the case is Tennessee's ban on a medical treatment that involves puberty blockers, which are medications that delay the onset of puberty, and hormone therapy, which give hormones to allow people to develop in accordance with their gender identity. Tennessee has banned the puberty blockers and the hormone therapy for people under the age of 18, and courts, actually, somewhat to my surprise, the federal courts have knocked down these bans, overwhelmingly knocked down these bans, but the Sixth Circuit recently upheld Tennessee's ban. That's going up to the Supreme Court on the question of whether those bans violate the Equal Protection Clause. So the claim is that the government, the federal government, has intervened and said these bans violate the Equal Protection Clause on two grounds. One, they discriminate on the basis of sex, and two, they discriminate on the basis of transgender status. It's a really interesting case, in part because puberty blockers and hormone therapy are allowed for minors in Tennessee who are not transgender. So people who have various kinds of medical conditions need to take puberty blockers, and people, this is so interesting to me, people who are intersex or who have secondary sex characteristics that they don't, that they're, let's say they're a male and they have breasts, they are allowed to take hormone therapy to become more male. But somebody who, with the hospital labeled male at birth, who wants to take hormone therapy to become more female is not allowed to. So it's a really interesting case where it's not a ban actually on hormone therapy and puberty blockers. It's a ban on using those to treat transgender youth. And so that's going to the Supreme Court. It will be very interesting. It implicates a lot of constitutional questions and a lot of questions about equality. Look out for that one in the news.
And so we'll see you all in a year. Thank you all very much. Please thank our panel for this stimulating discussion. Take care.